Don't ever go to the Medicaid office for answers. The Medicaid caseworker is not your friend. Don't do it, because this is what's going to happen.
Hi, Jeff Marsace, the Plain English Attorney, and welcome to the video. This is going to be put out in 3 parts, and this is actually an interview that was done with HD Reach on some very important topics regarding Huntington's disease, planning ahead, and trying to make sure that you're not losing everything for your loved one to get the care that they need. Now, the reason this is going to be put out in 3 parts is, honestly, we just need a little bit of time. We've got a big conference coming up that I'm presenting at. We've got a new book that's just about there and ready to launch. So we're going to need some time. So the video over the next 3 weeks is going to be this interview. And then after that, we hope to get back to a more steady flow of fresh content every week. So please enjoy the video and look for the book launch soon of the Divorce Firewall Strategy.
Does it make sense sometimes for families to, not always choose the same person for healthcare power of attorney and finances?
Absolutely. I try to keep estate planning easy for my clients, and I tell them, look, the complicated stuff is for me to figure out. But really, you've only got to answer 4 big questions. And the first is, who do you trust to handle financial things for you? And I lay out a scenario. And I'm typically saying, look, it's really, really, really preferred if you name one person and then a backup and then a third. And I hear all the time, oh, can I just make all 3 of my kids co-trustees or co-powers? No, bad idea. Bad idea. But then the second question is, who do you want making these healthcare decisions for you? That's really a completely different set of skills and background, and potentially a different kind of empathy and knowledge. Yeah, that's definitely, there are a lot of times when my clients pick different people for those 2 things.
Okay, I got another question for you that's not on here.
Okay, go ahead.
If you have guardianship of somebody, once that person passes, that guardianship is no longer in place, right?
Correct.
So what happens? Like, does that go over to the power of attorney, or does it go, how does that work after somebody passes?
If you think it's important for educational videos like this to get out there, then please help us out by subscribing to the channel.
Okay, guardianship, if you call it living probate, on the financial end, that's really what I'm talking about. On the financial end, you're reporting to the court, you're keeping track of everything, and you're accounting everything. You're going to have to do a final accounting. And then it goes over to the administrator or the executor of the estate.
Okay.
So now they have to pick up, and it's a different probate proceeding because now it's in the estates division.
Right.
So there's that handoff. Power of attorney, that ends when a person passes on. For both healthcare and financial, it's just no longer in existence. And I've had clients come to me initially, yeah, I'm trying to wrap up my father's estate. He passed on. I went to the bank and gave them the power of attorney, and they told me I couldn't. And they said, just go get this thing called letters testamentary. Can you type that up for me? Like, whoa, wait a minute. That's starting a whole probate process. Point is that power of attorney is done when someone passes on.
So if you don't have somebody chosen for after you pass away as the executor of the estate, what happens?
Well, then your closest next of kin gets priority, but anybody can go in and apply to be the administrator of the estate.
So it's really important to establish an executor of your estate, no matter what you have, right?
Yeah. If you're going to do that, that's in the last will and testament. Here's the executor. So anything that ends up in probate, they're in charge of, they take it through the process.
Got it.
So that makes complete sense. Even if this individual doesn't have, assets, they don't have all of these things, they might have just a little bit what's left to their name or whatnot. But if you're wanting somebody specific to be able to manage that or to be able to divvy that up, their chair, their, what, like
Yeah.
you're going to want somebody that you trust, and that's going to be a will. Is
Yeah.
that correct?
Yes.
If somebody does have, let's say they don't have many assets, they don't have a lot to their name, they're definitely lower income, and they're going to be looking at placement. Is that something that they would need to go to a Medicaid attorney for, or is that something that they just go up to their Medicaid office and?
Well, okay. First thing, don't ever go to the Medicaid office for answers. The Medicaid caseworker is not your friend. Don't do it because this is what's going to happen. And they go, oh yeah, well, I went down there for my mother and that's exactly what they did. You're going down to quote, ask questions and say, okay, well, just fill out this form. All right. You start filling out the form and okay, there's a lot of stuff about what assets you have, which is what they look at. And they go, okay, sign there at the bottom. Okay. And they take the paper and they go, your application has been denied. What application? That thing right there. You signed an application. We were just trying to get answers. You told us to fill out this form. No, your application has been denied. And now suddenly, here's this rejected application on file. It becomes 10 times harder to go back and apply for Medicaid with the genuine application, even if everything that you did to move stuff around and reclassify and put money here or change it to this thing, even if it's all above board, you've got a lot more scrutiny. And so if you come to me, it's like, yeah, I have a rejected Medicaid application. Now it's 10 times as difficult for me. And everything is looked at and scrutinized, as opposed to if you came to me in the first place and we moved assets around and changed things. So that's in general for just the Medicaid application. I had another client, well, she called up and I referred her to a colleague of mine, a non-attorney who was still able to help out. They had done everything they thought they were supposed to do, and they could have saved so much more, but they spent everything down. And it was really an aunt, and her niece was the person who was her power of attorney. And the house needed repairs and all this other. Well, they didn't do that. They spent the money on her care, just like Medicaid told her. But she's allowed to keep a primary residence up to a certain equity limit. I couldn't tell you what it is right offhand, but it's a pretty high amount now. Back then, I think it was hovering somewhere around $500,000, and it was definitely under that. So you can keep that and get Medicaid. The caseworker called up the niece as soon as Medicaid started to kick in and pay, because they spent everything else down, and said, oh, how's your aunt doing? Well, she has good days and bad days. Oh, okay. Do you think she's ever going home? Oh, no, I don't think she's ever going home. 3 days later, she gets a letter in the mail that Medicaid is turned off until they sell the house because the aunt's not going to go home. You always have to have an intent to return home, but it's a subjective intent. She specifically called that niece to try to trick her into saying she won't be home or won't be going home so they could make her now sell the house. My colleague straightened that out for her pretty quickly, but that's, again, just showing the Medicaid caseworker, they're working for the government. Now, they're going to process the applications, they're going to follow the law, but they're also going to get advancements and promotions and other stuff if they can save money. So you really want someone who's on your side. Now, if there's someone who really is that destitute, they have nothing. They have less than $2,000 in a checking account, and there's that need, and they are otherwise qualified for it. Then it's just a matter of filling out the application the right way and making sure that there's supporting documentation. So I work with a team of people on that, and that same colleague is kind of the application and paperwork factory. He's got people who can handle it and get everything put together so that I think it's something like 95% of the time the application is approved first time around. because they know what they're going to be looking for.
That is very, very good to know. As I think we hope people are working in the best interest of people. But that's obviously not always the case. And when you have somebody like an attorney like yourself or somebody within the Medicaid legal aspect of it, it sounds like it's better to have somebody in your corner than not, especially even if it is, there is property, if there is a house, there is some excess and, there's some savings accounts, there's some of, it sounds like having a conversation is definitely worth it instead of just going in blind.
Absolutely. And there's a lot of materials out there that will go over stuff. You definitely don't want to take the advice of your brother-in-law's neighbor's barista whose mom went through this and they said they did this and everything turned out. No. You really want to make sure you're doing your research. Now, if with the nature of HD, if you're immediately moving into planning and you've got those assets, there's a lot that can be done because there's a 5-year window. You might have heard of the 5-year look back period. It applies to gifts. So, all right, here's the most basic setup. We call it the 2-trust solution, even though there's more trusts really involved. There's an irrevocable property trust and an irrevocable family trust. For the property trust, you put the real estate into the property trust. And you keep the right to whatever income is there or in the right to live on the property. That's really more of a tax thing after you're gone for the beneficiaries and the heirs. And then the family trust is where you put all the money that you're trying to preserve. And then 5 years after you move all that stuff into those trusts, it's off Medicaid's radar. And while that sounds great and wonderful, and why isn't everybody doing this? It's because when you put those into the trust, you're no longer the trustee. Somebody else has to be in charge, and it can't be a spouse. It can't be, it can't be your spouse. It's got to be someone else. And so you have to be comfortable giving up control of your own assets at that point in order to start that 5-year clock by putting assets into the trust. Does that mean if they're not willing to do that, or if they don't have 5 years, they only have a couple of months before that skilled level of care is going to be needed, that there's nothing that can be done? No, it doesn't mean that, but it does mean you need to be a little bit more creative. Now, this is a solution, and it worked out so well that I tell this and give this as an example of, quote, last minute, even though it was really a couple of months. And this was for a mom who had dementia, but it was kind of early stages, and they really didn't know how long it was going to be until she needed that next level of care. And she was fortunate enough between her pension, her deceased husband's pension, Social Security, that they were really only pulling about $6,000 a year to pay for that level of care that she needed. She didn't need any help with getting dressed or toileting or eating or any of those activities of daily living, but you couldn't let her walk outside because she would get lost, she would get hurt. So it was that short-term memory and the confusion. That's why she needed to be in the environment she was in. All right, well, what did she have in terms of assets? She had about $340,000 in a checking account because she sold the house when she went into the facility. So that was being invested for her. And the only other really big thing, other than the couple of thousand that they kept in the checking account for her, she had this life insurance policy. Now, this was an important thing because this was the inheritance for the kids. When she died, it would pay out $400,000, but it had a cash value in the account of $60,000. Medicaid would look at that as $60,000. So total, she had $400,000 of assets. If you went down to the Medicaid office or called them, they'd say, go spend $398,000 and then come back to us. Wait a minute. She's allowed to have a primary residence or part of one. And if, just in case, if this is in the video and someone's outside of North Carolina, this may not work in your state because some states have different rules. Her daughter, who was the power of attorney and son-in-law, had a house worth $500,000 paid off. Well, wait a minute. Mom can buy 80% of the house. And now on the deed could be 80% mom, 10% daughter, 10% son-in-law, the three of them owning them in those percentages as joint with the right of survivorship. So when mom passes on, the house goes back to the kids. All right, well, she didn't want to just get rid of the life insurance because she would have gotten 60,000 out, but she wanted that 400,000 to go to the kids when she passed on. So what do we do? Because you can't really just make that part of the contract. The son-in-law had $60,000 and bought the policy for exactly $60,000. So now he owns the policy. Mom has 400,000 in cash, had the contract, did the deed. She bought into the house. Well, now mom has her house, but the daughter and the son-in-law have $400,000. And they're like, well, okay, it's our money because she bought into our house, but morally we're looking at this as if it's mom's money. So they took it and moved it into the irrevocable family trust. There's no 5-year look back period because mom wasn't the one who put it in the trust. The daughter and the son-in-law did. Okay, so now there's 400,000 in this trust. What's the first transaction they did? They bought the policy from the son-in-law back and moved it into the trust. So within a couple of months, we filtered through the biggest bulk of her assets, and she met that asset test now for Medicaid. Now, medically, she never actually reached that skilled level of care, but we could have had the asset test met immediately if she needed that level of care. So there are some things that you can do, quote, last minute, but with a couple of months' time to avoid having to pay those large bills on your own and qualify for Medicaid, but you really do have to be creative with the way you do it.
Is there I find that fascinating, and I'm so glad you told us about that because I would have never known. But is there an age limit for the person who runs the trust?
Well, okay. Technically, they've got to be 18. They've got to be a legal adult. The vast majority of my clients wouldn't want to put an 18-year-old in charge of several $100,000 of money. If they're that young, more often they're going to like their own siblings or even friends and cousins that are a little bit older. In fact, for just in estate planning in general, my clients are typically picking an age of inheritance of 40, with the understanding that if they're gone, the trustee can judge that beneficiary's maturity level and they can always give them the inheritance early. 40 tends to be the age that most of my clients universally agree. Look, if you haven't gotten your act together by the time you're 40, you're not going to. So holding it back doesn't do anything. Just go ahead and give it to them. It's going to go.
Yeah.
All right.
Makes sense.
So we have some who have financial difficulties when it comes to if they are seeking out Medicaid, there may be not many funds. Is this something that is just, I mean, it's recommended like saving, or are there resources that people can go to at least maybe do a consultation and kind of see if this is something that they really do need to be a little bit more creative and if it's worth kind of coming up with funds to hire an attorney for this?
Okay. What I typically do, there is a charge for a quote strategy session. If within 15 minutes of that quote hour and a half, I'm like, okay, there's nothing that I can really do, or it's so simple. Here are 2 things you just need to do. Okay, usually I'm just letting that go, but even then, in a couple of $100, if it can help you save a few thousand, great.
Okay. Absolutely.
But we do have materials that we ask our clients to read or go through, and a pretty detailed questionnaire. And it's really detailed on the financial end because that means so much when it comes to Medicaid in particular. Once we've got that information, we're able to really see pretty quickly, is there something we can do or not? And sometimes that may very well just be, all right, well, okay, you told me you've got some of these medical bills. Those medical bills are going to be there whether you spend the money on something else or not. So you might as well spend it on that. So there's that debt isn't there. You're allowed to have a vehicle, but right now you're really driving around a car that's old and in need of a lot of repair. Well, if you're going to be driven around in a car for appointments and other stuff and someone else is going to do the driving, well, why not get a good vehicle? And then that might take care of it. So that'll help you, quote, spend it down in a reasonable way. Again, you go to the Medicaid office, they'll just tell you to keep spending it on your care.